Committee Room 21. Signed. Committee Room 21. Signed. Committee Room 21. Signed. Signed. Committee Room 21. 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 Signed. Committee Room 21, 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 signed. Committee Room 21. 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 Signed.
We're just about to go into public session. Okay, thank you. So, good afternoon, members. You're welcome to the meeting. Just to remind you that we are being broadcast online and throughout Parliament buildings. Just want to welcome our members online today. We've got Stuart Dixon, Deputy Chair, Sinead McLaughlin and Claire Sugden, and I think we're waiting for Anya Murphy to join shortly. And anyone else watching online, you're also very welcome. Just to remind that your mobile phones should be muted and that there's no recording or photography of the meeting allowed. Okay, if you're happy, we will proceed with the agenda. Okay, so there's no apologies as yet. So declarations of interest. Do members have any interest to declare in relation to this? Okay, go ahead please, Pam.
Thank you, Chair. So I wanted to declare my previous role obviously as Junior Minister and that I would have had sight of policies around executive office and other departments.
Okay.
So it may be best, I believe, that you do maybe have a system of a standing declaration that so they don't have to keep parting every time. That would be good.
Okay, no problem. Thank you, Pam. Go ahead, please.
Thank you, Chair. Item 6 is the presentation from Wave Trauma Centre. My dad is a former employee of Wave Trauma Centre.
Okay.
And then item 10.6, Troubles Pension Scheme. My mother is in receipt of a pension.
Okay, thank you very much. That's great. Thank you. Okay, so just on that, Chairperson's business there, updated membership. So I just would like to formally welcome Pam Cameron and Philip Brett to the committee, and I would like to place on record the committee's thanks to Brian Kingston and Harry Harvey for their work during the time on the committee. So just like to seek your agreement to write to the two outgoing members of the committee to thank them for their tenure.
Great.
Okay, thank you. Okay.
Anya's arrived as well.
And welcome, Anya Murphy's just arrived there online too. That's everybody. Okay, so 3.2, the Truth Recovery Independent Panel. So members, I'm going to refer you to pages 5 to 7 of your meeting pack and just advise that I had received this correspondence from a member of the Consultative Forum regarding the extension of the term for the Truth Recovery Independent Panel. Just to advise that the panel has been granted an extension of term until the 31st of March 2026 by the First Minister and Deputy First Minister, and this is to ensure the panel's findings and recommendations to the forthcoming statutory public inquiry are fully informed and as detailed as possible by allowing more time to study both the testimonies and the archival records. The panel aims to complete the report by the end of this calendar year, and then January and February will be spent checking the accuracy of the report and ensure that any legal issues are dealt with before preparation for publication in March. So I'm just asking you to note this and to remind you that the panel, the Truth Recovery Independent Panel, will be appearing before the committee at its meeting on the 8th of October. And I am going to raise this with the TO officials when they come in. So if anybody wants to hold it, go ahead, please.
Just on that, there were some concerns raised previously about their leaflets that they put out via post, about them not being received in all areas of Northern Ireland. The committee had some concerns regarding that. Did we ever get any response, or did we ever ask any questions regarding geographical areas that were missed?
Ask the question.
No, we didn't.
We haven't got a response. Can we just pause this, because I want to raise some issues as well in terms of this panel, in terms of the costs of it and the purpose. So happy to move on. We just note that.
And Chair, do you remember the 80 grand Brown and Thomas got for communications?
Yes. I think that what this letter has indicated, that extra money was well spent, in that it then brought forward a lot more people to provide testimonies, and it's those testimonies that they're now going through.
So I understand that, but the point that Timothy and that we have made before, there were concerns either when people got the leaflet, they got it and that was fine, but there are many people who since said they genuinely weren't aware till they heard from others. So I'm not saying 80 grand isn't well spent. I'm just saying if it's around communications and outreach and inclusion of people, then we need to find out what's happening.
My concern would be geographically there's areas that didn't receive the leaflet.
Yeah, I think that we're specifically targeting, but by targeting them. But anyway, I think we could maybe pick that up.
Well, Chair, they are in front of the committee in 2 weeks' time,
Yeah.
so obviously it's something that we can follow up at that point.
Okay, so
Can we let them know
We will
in advance
indeed.
so at least they're coming with answers?
Yeah.
No problem.
Thank you.
Okay, thank you. So item 4, draft minutes. So you'll find these on pages 8 to 24 of your pack. I just ask members if you're content that these are a true reflection of the proceedings of our meeting on the 10th of September.
Great.
Thank you. Okay. Oh, sorry, 17th of September. Okay, so I'll go ahead and sign. Okay, so matters arising, 5.1 consultative forum. So members, I'm going to refer you to pages 26 to 36 of your pack for a copy of the PowerPoint presentation from the consultative forum that was referenced during the oral evidence session at last week's meeting. 5.2, birth mothers and their children together, refer you to pages 3 to 4 of the table pack for the additional information sent by birth mothers and their children for justice group in relation to baby homes. 5.3, birth mothers and their children for justice. Sorry, that must be, oh yes it is. You can find their additional information on page 5 of the table pack regarding the additional institutions, and I think that was something that Stuart Dixon was focused on last week.
Yes.
Okay, so I don't think there are any actions there, are they?
Yeah, just to go to the Truth Recovery and give the concerns that members have raised
Yes.
in front of their meeting in a couple of weeks, that's fine.
Okay, good stuff. Okay, so members, we're going to move on now to item 6, and this is our first evidence session today. So I'm just going to seek your agreement for Hansard to record this session.
Right.
Okay, thank you. Okay, members, I'm going to refer you to pages 38 to 41 of your pack for the clerk's brief, and pages 42 to 58 of your pack for the written submission from VSS, Wave and Adopt NI. Okay. Just to advise the members that the TU officials who will be coming up next are watching from the gallery as well, so that will allow for flow, easier flow. Okay, so you're all very welcome here today. We're going to be looking at our bill under the inquiry in the redress scheme, and so welcoming to the meeting we've got Andrew Walker, the Chief Executive of VSS, Sandra Peake, the Chief Executive for Wave Trauma Centre, and Ciara Scully, the CEO of Adopt NI. So thank you for your papers in advance. I thought that they were very useful, very well set out, and I would ask you just to make some opening remarks, please. Thank you.
Thank you, Chair. It's okay, I'll make some remarks on behalf of all three of us. So, good afternoon, Chair and members. Thank you for the opportunity to speak to you again today. I'm Andrew Walker, representing the Victims and Survivors Service, and I'm joined by colleagues from our community partner organisations, Dr. Sandra Peake, Chief Executive of Wave Trauma Centre, and Ciara Scully, Chief Executive of Adopt NI. We appreciate the invitation to contribute today as you continue your important work in scrutinising the bill. So together our three organisations form a partnership, and we've been working together since September 2022 to support victims and survivors impacted by these institutions, their pathways and practices. Since the launch of the services in 2022, over 500 individuals have accessed support. Our model is survivor-led, trauma-informed and built on collaboration. Our roles are distinct, so VSS is an ALB of the Executive Office responsible for delivering support and services both directly and through the appointment and funding of community partner organisations. Wave and Adopt NI are our community partners and are independent charities engaged directly in community-based service provision. But our shared purpose is clear: to ensure those who have been affected are heard, supported and empowered. The bill before you represents a significant and welcome step forward. It offers the potential for truth, acknowledgement and redress. It also brings with it a responsibility to ensure that processes that it establishes are not only trauma-informed, but also ethically grounded and emotionally attuned. From our experience supporting victims and survivors of the Troubles and conflict, and also survivors of historical institutional abuse, we know that the design and delivery of processes relating to truth, acknowledgement and redress must be trauma-informed at every stage. Survivors are not simply participants in the process, they're individuals whose lives have been shaped by profound violations of trust and care. The systems we build together under the direction of this bill must reflect that reality. We must be mindful that even well-intentioned processes can risk re-traumatisation if not carefully designed and delivered. That is why the trauma-informed principles of safety, choice, trust, collaboration and empowerment must be embedded throughout. With that in mind, we particularly welcome the bill's provision for the Chair to appoint an advisory panel. We believe it fundamentally important that the survivor voices are embedded firmly within the mechanisms of the inquiry. Survivor participation is not just symbolic, it is essential to the credibility and effectiveness of the process. International best practice shows us that inquiries that are strengthened when survivors are not only consulted, but included as experts in their own experience. We also highlighted the importance of access to records, both to support participation in the inquiry and to enable applications for redress. We know that access to records has been and continues to be challenging for survivors and their families. Without effective and timely access to personal records, many survivors will face barriers to engaging fully with the processes intended to support them. This is not just a technical issue, it's a matter of dignity, identity and justice. As the processes around participation in the inquiry and application for redress are developed, it is crucial that the reality of survivors' experiences of accessing records is understood and taken into account. In parallel, efforts to make the process of access to records more efficient will bring great benefit to survivors seeking to participate in the inquiry and/or redress, which will in turn improve the effectiveness of the inquiry and redress scheme themselves. On redress, we re-emphasise the value of co-design, mapping the applicant journey, involving survivors in shaping regulations, and ensuring clear, compassionate communication will all be critical to building a scheme that is trusted and effective. We've commenced this work already with colleagues in the Executive Office and with the Shadow Truth Recovery Redress Service. And we know from experience that when survivors are involved in shaping the systems that affect them, those systems are more likely to be responsive, respectful, and fit for purpose. We also note the sensitivities around posthumous eligibility, payment levels, and time limits. These are complex and emotive issues. They touch on grief, recognition, and fairness. The bill proposes a posthumous cut-off date of 29th of September 2011, and we're aware that many survivors and their families feel strongly that a different date or no date at all should apply. The consultation process also led to strong feelings among survivors around the values of proposed redress payments for applicants and about posthumous applications. Beyond the bill itself, we must also consider the wider context. Survivors will need ongoing support whether they engage with the inquiry and redress scheme or not. Communication is critical. We know from other similar processes we've been involved in that communication must be clear, consistent and compassionate, and designed not just to inform but to reassure and empower survivors. Survivor voices are central to success in these sensitive processes. We note the ongoing role of the consultative forum and the need to ensure clarity for survivors over the roles and remits between the consultative forum, the advisory panel when formed, the Executive Office, Victim Survivor Service and our community partners, particularly in relation to advocating for survivors. So finally, we want to reassure the committee that VSS, Wave and Adopt and I remain committed to supporting victims and survivors both before, during and after this bill. We will continue to work closely with the Executive Office, the Shadow Truth Recovery Redress Service and most importantly with those directly affected. So thank you again for the opportunity to speak to you today and we look forward to taking some questions.
Okay, well thank you very much. I should say that the VSS, for anybody watching online, is the Victims and Survivors Service. I'm just conscious we're always using the abbreviation. So thank you again. So I just wanted to pick up on the comments you made around the responsibility for this process, the inquiry, to be trauma informed and the traumatic nature that this will involve. And I'm very conscious that we have had a lot of inquiries here in Northern Ireland which can sometimes leave people, the campaigners, feeling quite let down. I'm just wondering, how can we best meet their expectations, and also how do we reflect that there could be a divergence in aspirations or expectations from the birth mothers to the adult adoptees?
Yes, well, I suppose in terms of a trauma-informed approach, it is really about building in those trauma-informed principles of trust, safety, choice, empowerment, collaboration. I think we've seen the beginnings of that even from how the committees started this process, which is important to have it from the beginning. I know you've had familiarisation sessions and allowed people to understand what this process is going to be like. I think we need to apply that same approach all the way through the different elements of both the inquiry and redress. I think we have very much started to do that in how we work with the Executive Office colleagues on the redress side of things. So we're ensuring that we learn from the experience of the previous processes that we've been involved in around HIA, around Trouble's Permanent Disablement Payment Scheme, and some of the learning that came from that in terms of communication in particular, and how we communicate at different stages of all of these processes. The environment that we're in, the environment that will be there with the inquiry, and if there's any oral hearings with redress, it's all really important to build that in a trauma-informed way. Sandra, if you've been involved in some of that as well, I think.
Yeah, and I think the big thing is about the clearness of language, to ensure that, when people feel excluded because of the bill, to look through in relation to why they feel excluded in relation to where the regulations are. And I think learning from the experience of survivors who went through HIA and embedding that at this stage particularly has been really key, and obviously the executive team have done that. Because ultimately where systems fall is when communication isn't clear, when people view it as re-traumatising, and when individuals feel there's no control. And whatever we do, we need to build a sense of control into all processes.
Okay, thank you. Just sticking with the inquiry then, so you mentioned the advisory panel, which is detailed in clause 10, and it's listed there who will form it, those who are admitted to a prescribed institution, etc. I'm wondering if you have any thoughts on the sort of overburdening of people who have a stake in the inquiry, but then will then have to put on a slightly different hat to be on the advisory panel, and then the potential conflict where people were like, why were they picked to be on the panel and I wasn't? And I'm just wondering if you have any thoughts on how best that should be managed and whether the bill is sufficient in terms of how that could be handled.
Yeah, I suppose the most important thing is that it is in the bill in the first place, and I note that it is a stipulation that the chair may appoint a panel, and I think we'd all be very supportive of will appoint a panel, and the panel would be in place. And I think it is really important that is from a wide range of views, and that will be difficult, will be challenging. I think the support model that we have to support people engaged with the inquiry, many have been engaged with the independent panel already in terms of testimony, which is another good example of a trauma-informed approach in respect to the previous question. But supporting people to engage at all the different elements of this, so the advisory panel, any other aspect of the inquiry and redress, all of the wraparound support will be there for that. Sandra, do you have any?
No, I think the big thing is that lived experience and ensuring lived experience is enshrined within any process will only be of benefit to it. It's how it's done and the need for safety and care around it and preparation for those who are going to sit on it to manage that. And I suppose the most comparable example for us would be the fact that we're looking to train people to be citizenship educators, where they use their experience in relation to helping other statutory institutions understand their experience. And I think the more that preparation can be built in, but lived experience, the voices of lived experience should be heard.
Okay, just moving on then to the redress scheme. So I'm not sure whether you were watching last week, but taken, for example, I think it's maybe directed yourself, Sandra, it's around sort of the profile of those accessing the specialist services at the minute. And I think in the submission you talked about that the 10,000 is not reflective of current economic times. We heard last week, for example, that from birth mothers and their children together around the fact that, if the amount was higher for the for the standardised payment, then it would reduce the number of people coming forward for the individually assessed redress payment. I'm just wondering if that's something you have picked up in terms of.
We have, and after the committee, I'll provide some case material to you on that. And there's very strong feeling on that, particularly for those who are older, yes, because they feel by the time that the process comes through, it might be too late for them. So that's why there's a particular issue in relation to a feeling that the amount awarded is not reflective of current living today, but also in relation to the timeline, in relation to life expectancy for some. So I'm happy to furnish in some case studies and some examples and the voice of people who feel very strongly about that.
Thank you. Just one last one for me, and that's, again, the papers were so useful. I hadn't really thought about the issue around the original birth certificates, and this may be something for yourself, Ciara, around the admissions-based redress scheme. And I'm just wondering if you could maybe speak to us a wee bit about how there's potential barriers or there's potential difficulties you can foresee around not just for the applicant but maybe their deceased relatives.
Yeah, and I think it's especially relevant in terms of deceased relatives and posthumous claims. But in the first instance, for an adopted adult even requiring access to their original birth certificate, it's our experience many come to us as the first instance because they're at the very start of the journey and haven't uncovered any of that information. So there's currently barriers within that. There are waiting lists within the trusts for access to record services, which is something we really feel needs to be looked at. But in complex cases also where we can't find the record of birth or there was an illegal registration, findings, for example, which will take longer to evidence the birth registration in some cases.
Mm-hmm. Okay, thank you. I'm going to go to Carol, please.
Thank you for your presentation today and indeed for the report that came in before the committee. You are very strong, certainly on the co-design aspect and the journey of the applicant. But what does that, so already you can see that there's the support that you offer and then there's support that others offer. In terms of going through this process of the legislation and indeed the inquiry and then the redress, what does the applicant, support for the applicant going through that journey look like? That's my first question. And then my concern around clause 10 is, and it could be something we can pick up with officials, but when I see may rather than shall, I get worried. So, you know, like the chairperson has the ability to do the panel on their own. So it's just to try and get your thoughts on that. So if you want to start there.
Yep, sure.
Thank you.
In terms of services and support and what that looks like, I suppose services and support back from the beginning of the co-design of those services in 2021, it's always been aligned to what has been happening at the time. So it was the original sort of consultative forum moving forward into the Truth Recovery Independent Panel and the support around that, and now planning the support around this piece of work from the committee and the support that we can have there, and also planning forward to what that looks like in the inquiry and in terms of supporting people specifically with applications for redress. More generally, the service and support, it's a needs-based trauma-informed model, as you would expect. It's a combination of services directly from VSS or the community-based services from our partners, and the access to that for individuals normally is through, you know, a conversation on their needs. It's what we call an individual needs review, which will generally happen within the community partners, and that leads into the services that are required at that time, depending on what that individual needs, and that will obviously be impacted by what elements of this process that they're engaging with. But in the community and voluntary sector, we're looking at, you know, social support, talk and therapy, support with their testimony during the independent panels work, complementary therapy, welfare, personal and professional development, and then some of the specific services that Adopt and I specialise in around family trace and the DNA testing pilot, which I know the committee's interested in from last week. Maybe get to that. And then if there's more sort of individual specialised needs, complex needs that VSS can directly support the individual with through our frameworks, we've got what we call the Individual Needs Programme, and that provides support in areas such as persistent pain, psychological support, education and training, disability aids, trauma-focused physical activity. So there's a whole suite of services. There's a really good route to accessing those services, and individuals can be in touch with either the community partners or directly with VSS, and we do work it in that partnership to make sure that people get to where they need to be.
I'm sure you are concerned, or maybe you aren't, I won't put words in your mouth, but certainly even some of the presentations from some of the witnesses, some of the victims and survivors have said that one of the big anxieties that they have, and I have many, but one of them is their age, and come through this process, particularly when you get past you know, the individual payment, and then you need to go in, or the standard payment, you need to go in and give evidence. I'm just wondering, you know, what else can be done, because I think we still need to try and deal with this in a very sensitive way. Yeah. But many will still, I mean, some are only, and adoption and I will know this, but when you get your birth certificate, it says adopted on it, and that's traumatic, and then trying to access their records, and then trying to access what happened to them from people who are really colluding to keep things secret, and I'm just wondering, what else is it you think that those people need when we're going through this legal process, going through the process of the legislation, pre-inquiry, post-inquiry? What else do you think it needs done to support them?
I think the suite of support that we have in terms of the health and wellbeing, the emotional support is good. Okay. I think we need to ensure that there's the investment there to scale that up in line with the number of people who will likely come forward as we move through these processes. The one area that is probably, already mentioned, that will cause difficulties, not just at the end, when we get to the point of an individually assessed payment, but even at the standardised payment, will be that access to records. And Ciara can maybe say something about how the complexities of that at the minute. So I think there is a recognition that, colleagues, particularly in health trusts, are fully occupied with the matters of today in terms of child protection issues, and the need for some investment there and support for those colleagues to be able to help with the release of information is going to be essential right at the beginning, actually, at the standard payment aspect.
My final question, Chair, is then if you go to clause 16 and the issue that I've raised previously in relation to disclosure, I mean, if you go from clause 15 right from, or 14 right from public access to inquiry proceedings and information, right through the restrictions on public access, and then powers and required the production of evidence. I mean, we all understand the data protection, but in the face of an inquiry that's trying to unearth who someone is, and we still have these technicalities which on one hand are almost standalone in the face of a public inquiry trying to get access. So how would you advise people to try and go through that? Because as it reads here at the minute, it's up to the chair to decide what access they can have, and I think that's completely unacceptable. So in your view, in relation to these clauses, how do you feel?
I care that's you would jump in.
We had talked about mapping out a client journey in terms of the process for inquiry and standardised redress, standardised payment, which will allow us to mitigate against some of the issues that we'll face or the barriers to participation, that we can work with them to help maybe uncover information, but we know it's not a one-stop shop.
Yeah, no, fair enough. Have you got concerns around those clauses, given what people already experienced?
I think it's more around timelines, particularly on the redress side. It's around timelines of how quickly people will be able to get information, and some cohorts within that will find it very difficult to get information. I think there is powers to compel. I think within the redress service, but then that opens up other issues as well around accessing information that then potentially couldn't be shared with the applicant themselves. So all of that is being worked through, I think, at the moment.
Can I say I think that's one of the issues is it's deeply traumatic for people, and one of the case studies we will give you is where people are having to go back not once, not twice, up to 4 times for information and then to be charged. So I think that there needs to be clear thought given to that. But the client journey is really important because the silence and the sense, that silence within communities of people who have not been recognised, never been recognised, have been made to feel shameful, have been excluded. All of those things are really important to how the approach is taken, and how, and certainly we and Adopt and I together are working so that the whole regional address opens up access for people wherever you are. So if you're in Strabane to Antrim to Ballycastle, that we will be able to provide direct access to you with face-to-face services, and that needs to happen because it has to be more than people need to be able to see who they're dealing, and for trust to be built, particularly given the ageing profile of the group.
Thank you, Chair.
Thank you, Carol. Timothy, please.
Thanks very much. Just picking up on something you said there, Andrew. Information not being shared with the applicant. What would that look like, or what could that be?
I think that this is very much in the early stages of thinking through what it would look like to be able to access information that the redress service will need to process an application, because there are powers there to compel. So there's potential that information could be accessed by a truth recovery service, but it's a separate process for individuals to access that information. I'm getting that correct, I think.
I can probably, if it's helpful, send a case study across to help to illustrate it, where there's a lot of back and forward between an institution and evidence not found, and then maybe we're able to supplement with evidence of a birth certificate, or find out that somebody was in a workhouse, for example, and then go back to the institution and maybe a bit more information is uncovered, but we can supplement that and help to validate.
Why wouldn't that be shared with the applicant?
Question.
That's a concern I have, that you have raised that concern. So we're looking at a system where we're going to have redress payment for anybody that has been in an institution. The next stage of this will be somebody that has faced, there will be a payment based on their experience of what they've faced. If you're coming in front of us today and saying there'll be information that would be shared with the applicant, essentially that could put in jeopardy their phase 2 payment in this.
I think we're at the very early stages of working through what those problems look like and what the solutions to them will be. So I don't want to go too far in terms of saying that is an issue that can't be resolved, but it's part of the early discussions around how information will flow from the various sources to both the redress service and to an applicant.
There's obviously a conversation that has taken place that has put that doubt in your head, and that's something that concerns me greatly. If it's somebody's own personal information, they should be entitled to see that, and there should be no barriers put in their way that would rule them out of getting a Phase 2 application or evidence to support their Phase 2 application further down the line.
So an individual's right to access their own information is through specific processes, and it involves, in some cases, redaction of files, social workers. There's a process there that has to happen. Whether there's any other routes that information can be accessed is something that has to be worked through, I think, over the next as we prepare and design these processes for the scheme.
Moving on then to some of the questions that I had. VSS was set up in 2012 by the Executive Office, essentially to deliver for victims and survivors of the troubles or the conflict. What learning has there been from the 2006 order, which classifies a victim as a survivor of a conflict-related incident? Where I'm going with that is there's a realisation that you couldn't have somebody that was hurt by their own bomb in the same room as somebody that lost a son to a bomb.
Obviously, we're here to talk about the bill.
Yeah, and that's where I'm heading. We talk about a trauma-informed approach, and what we have heard in the past is where you have had birth mothers and adoptees put in the same room, which has created tensions before we've got to this stage, where we've heard about a client journey, and I'm really wanting to understand, has there been lessons learned? Like, this isn't the first rodeo for VSS. This is something that you've been through, where I'm talking about the bomber and the person that has been injured by the bomb, but we've repeated that and putting birth mothers and adoptees in the same room. So what assurance have we that when we get out of this, the other side, that this client journey will actually be a trauma-informed approach, and we're not going to rehearse and repeat the problems that we've established and we've seen through to get here, which has caused a lot of pain?
So the client journey and the applicant journey are primarily around that individual's route through to individual-based support. There are times when individuals will come together, either in group-based activity, which Sandra might say something about because we have led on a lot of that, or in forums such as the consultative forum or the advisory panel when it is formed, if it is formed, because I think it is important that there is that wide range of voices.
There needs to be an understanding of the tensions.
Yes, absolutely, and I think that's where the support and services need to wrap around. And as I said, all of the sort of support and services that we've put in place since 2021 in this space have been to wrap around the various activities that have been happening at those times, be it the consultative forum and the early stages of that, and that is difficult, of course, and VSS have been there throughout all of that period, all the way through to the independent panel's work, through your committee's work, and as we go forward into other services around the inquiry and the redress scheme. There are times when groups work together. Sandra, you've facilitated some of that, I think, already, so there's something you can say about
I mean, ultimately, I think there has to be care and support, but it's looking at where the individual is at and assessing their needs and working through with them in relation to a very clear plan of care. And nobody will be put into a position whereby the workers they will be working with them as they present and the issues that they have. But I think that for examples around consultative forum or the various initiatives that if people are happy to come to give I think there's going to be huge learning, because there can be many assumptions from birth mothers about the adult adoptees or adult adoptees about birth mothers, and I think if people are prepared to come into that and feel that they can share their experiences and their voice will be respected, then that can be a very worthwhile process. I think the more that people's voices are heard, because people have been silenced, they've been marginalised, they've been excluded. In some cases, the silence even permeates right down through their family. There's huge work, I think, in relation to supporting people and to give them the best in terms of the work that Adopt and I do in relation to tracing and DNA. If you don't have that, to have that and to have control over that is really important. But the big thing, I think, is about ensuring youth services where people are in control and they make the choices. It's not something that I may think is good for somebody or Andrew may think is good for somebody. It's what the person and they make the choice around how they want to contribute and in what way they want to be heard.
Next area that I want to ask some questions on is the reach and promotion. So looking at the victims' pension and drawing comparisons from it, there's only 1,000 people or less than 1,000 people in GB have availed of that. So we have a redress scheme. How can we make sure we have utilised and getting that information out there that people know, where in the past, right, compare it to the victim scheme where there's an under uptake. You think the amount of people that have left Northern Ireland that have came here maybe served for years and haven't looked for the victim's pension. How can we best utilise our resources to ensure we're getting as many people, yes, in Northern Ireland, the South, but also in GB, because that's obviously a problem in the past where we haven't been able to reach that audience.
I think one of the things that would be useful there would be an understanding of responsibility for communication around the scheme and for advertising and promotion around the scheme. There is obviously something in the bill around advertising of the scheme opening date, and that has to be done. I don't think there's anything else around who will take overall responsibility for promoting the scheme or promoting engagement with the inquiry. We will all play our part in that. But it may well be useful that we have a better understanding of who takes the lead and where the budget then would come from to do that work. We can all do targeted promotion through our own channels. There's quite a wide reach across, I guess, social media and other platforms that we would have between the three organisations. And we'll obviously do that. We'll obviously also try and target any information that we can get to places where we know that those who would be eligible may be. But I take the point and I agree that it would be useful to have a sort of a combined approach on that.
In Matters Arising, we had the slides from the Victims and Survivors Forum, the members' views. So out of that, it was sent out to 236 victims, survivors, only 54 responses. I just have a concern that we are not reaching the people we need to reach. And that's something that I want to put strongly on record of something we need to have an associated budget and a clear pathway of how we're going to get to these people. So looking at the redress and the £10,000 payment, so that was set 2015 essentially, and this is something I've explored with the groups that were in giving evidence last week, and there's a lot of victims that money will never replace or compensate for the experience they have. They don't care about the money, but there is some people that certainly that means something to them, that they're getting their recognition. So £10,000 in 2015, essentially with inflation, looks somewhere like £14,000 now. Is that a figure that better reflects the recognition? Is that something? What's the feedback on that to yourself?
I think there's a lot of different views in that, and we saw that with the consultation in terms of settling on what an appropriate figure would be, and again the same points that you've made about no amount or no figure will ever be a compensation. Other schemes have approached this in different ways. I think the 10,000 is often linked back to the figure that was maybe the entry level for payments under HIA, which was some time ago, but that did stay as the payment throughout the 5 years of the scheme. So if applying at the end of the scheme and the beginning of the scheme was the same amount, even though there was a period of inflation and cost of living between those two dates. On other schemes like the Troubles Permanent Disablement Payment Scheme, that's fixed to an indexed amount, whereby each year that minimum level, so it increases. So when we first talked about that scheme, I think the minimum level for the lowest degree of disablement was something like £10,000, £10,500 maybe. I think if you're applying today for 4 years into that scheme, that has already been indexed and it's at £12,000 and £12,500. So there's lots of different ways that can be built into a scheme, I suppose, is the point, and lots of different views as to whether 10,000 is an appropriate amount for this standardised payment. It is the lead-in into an individually assessed payment later on, but I think you heard clearly from last week that there will be many people who maybe don't feel that they will want to apply for an individually assessed scheme, and all of the difficulty that will go with that, or unfortunately may not be around to apply for that in time when it comes around. So.
Okay, thank you. I'm going to move on. Philip, please.
Thank you, Chair, and thank you very much for your presentations. I suppose in the first instance, useful for me just to put on the record, I've just joined this committee, so I'm getting up to speed too. I got access to papers yesterday, so maybe not in as much detail as I wanted to be, but I just wanted to get some views from you. Firstly, in relation to the core services that you offer. Obviously, I'm very familiar with the work of WAVE and with VSS. With the expanding workload that you have as a result of this bill, I just want to see how would that impact on each of your core services that you're currently engaged in.
So from WAVE's perspective, it's a separate team that work solely in relation to mothers and babies. That team, how that team is structured from a casework model differs in relation to the Troubles, and it's based in relation to feedback from individuals in relation to what they felt would be, wanting to work with one worker rather than working maybe over several workers. So we have shaped the service to meet needs based on client feedback. We will have we've just appointed enough workers in relation to working throughout WAVE's 5 centres, and then Belfast would have the highest concentration working out of a separate centre in Belfast. Yes. And that centre really is geared. I can't de-Troubles WAVE and what WAVE offers in relation to the Troubles, but what we can do is ensure people have a sense of place and space in WAVE that is bespoke to their needs, and that's in relation to mothers and babies, and also in relation to HIA. And so that will offer, we have applied in relation to the Victims and Survivors Service. We work very closely with Adopt NI in relation to trying to provide a seamless service. So, I mean, our work will be in relation to the health and wellbeing needs, and taking people through and gaining some records for them for an INC, but the specialism around tracing and information and records and recovery very much rests in relation to Adopt NI. And what we want to do is have that seamless service right across the board. I think that what we can see is that there's been a real certainly when we started in relation to the pilot project, there was a sense of reluctance from some in relation even to coming to a centre. We catered by offering evening appointments when the centre was closed, or Saturday appointments, or offering services outside, so they didn't even have to come anywhere near a WAVE centre. And I think it's about really open up as much accessibility as we can. But engagement has been really good. There are 270 people engaged with WAVE in support service provision. And the team are working very actively, and we think that will grow. The one thing I would say from a communication perspective, to pick up actually a bit on Tim's point, is that I think there is a need for very much a community information campaign, and we have tried to focus on community organisations that we're working with, and going in, the team were in recently in relation to the Shankill Women's Centre, and they've been in relation to other community groups in Uri, reaching out for people to let them know what's coming, what's happening, but what services are there. But the one challenge for us will be records in relation to allowing the process to open up for a full INC, a full individual needs approach. And so it's not, records actually are key right across for support service provisions too.
And then just in terms of each of your concerns with the bill itself. So Carol had rightly picked up on clause 15 in relation to may, v, will/must, but I wasn't quite clear from your answers. Do you support the bill, clause 15 as drafted, or do you believe it should change? So that's in relation to the appointment of the advisory panel?
Which is clause 10. Yeah.
Sorry, 10.
Yeah, no, I mean, we absolutely believe that there should be an advisory panel, and that the voices of survivors should be within the mechanisms of the inquiry. As worded, I think it gives the option for a panel to be appointed. I think our view is that it should be appointed. It should be a panel appointed.
And Ciara, that's your view of your organisation too, is it?
Yeah.
Yep. Okay. Perfect. And then, have you any other concerns then with any of the other clauses within the bill that you believe the committee should be focusing its work on?
I mean, the things that you heard, you weren't in committee last week, but the things that were raised by survivors appearing last week were pretty common around posthumous death, around the value. We've mentioned, to your point, around good communication and promotion and awareness of the scheme. I think those are some of the key things that should be.
Do we have a corporate position on what the payment level should be?
Yeah, they do, and I'll provide, because we've engaged, in terms of our engagement with the client base, so certainly the recommendation was that the payment should be nearer to 15, then, which would reflect any sort of, which would reflect the increase in cost of living, etc., and also from that time. Look, we appreciate that, and I think the point has been made here that it's, that for some people money is not, I suppose, the prime issue is around the validation.
Yeah.
However, if you are coming in later years, or indeed feel that you're younger but you don't want to go through the individualised needs process that will come later, it is important to have that very clear option. And I suppose we've seen the difficulties, particularly for survivors of HIA, that has come from having to put people right through a very, very detailed and quite traumatic process. So for some people, this may be all that they will receive through this, and that will be their wish. I think that we need to take account of that.
And then my final question is just on sort of expectation versus reality. It's maybe just a piece of advice from you in terms of how we as a committee can look at this bill in terms of victims rightly have a expectation that their needs and what they went through is going to be rightly validated. But as legislatures, we also have to make legislation in the realm of what is possible. So things around what finances may or may not be available to the executive, because I would be concerned about introducing a level of payment that builds up expectation with victims, and then we're going back to them having patted ourselves on the back for passing this bill to then say, sorry, there's no money there to deliver it. So I'm just keen to get your view in terms of, as a committee, I'm seeking your advice on this, but how we can ensure that the process that we go through, that we deliver legislation that can actually be deliverable and not build up expectation, which in my view would ultimately then re-traumatise victims once again.
I think in terms of any decisions that are made around amendments and how the bill evolves and becomes law, I suppose I would just urge to think about what the support will be needed around that. So if there are changes to things like posthumous date or to amount or to access to records, all of that will feed into how many applications there will be and the need for support and the scale of that, and that we're all well set for that and prepared and planned that when a scheme on an inquiry reaches the date where it starts, that we're all ready to go and we have the right support in place, and all of the decisions will impact on that, I think.
Thank you, Chair.
Okay, I just want to put on record, I think that we have asserted that if we put an amendment in, that it would go to 15,000, then it would be up to the Executive Office to find the money. So, do you know, I'm not trying to contradict what you've just said there, Philip, but, I think that it's not for us to try and justify why we would raise it up to 15,000, it would be up to the Executive Office to find it.
No, it'll be for us to justify, Chair, or whoever votes for or against, because we're all accountable in the Assembly to the actions that we take. So we can't just say that this is it and then have no expectation of how we deliver it. But I fully support getting victims as much as they can.
I'm saying if it passes at a certain amount,
yeah,
Got to find the money.
they have to
yeah,
find
no,
it.
of course.
So that is a worry for people who probably are watching today.
Yeah.
So I just want that to be cleared up. Okay, Pam, please.
Thank you, Chair, and thank you very much for your presentations today. Good to see you and good to hear some of the very good work that you're doing day and daily. Clearly this is a very, very complex and highly sensitive piece of legislation that we're dealing with, starting to scrutinise. And you know, it takes a lot to get your head around all the detail, and that will become more complex probably as we go through this process. But I wanted to check with you kind of and ask what understanding you feel victims, survivors, clients, whatever preferred terminology is, have around the initial payment that is proposed, so that how aware are they that this is an admission-based payment and that it's not the harm-based scheme which is to follow after the inquiry. I understand victim survivors have waited an awful long time to see this progress and to get to, and I think there's a real desire to see this through as quickly as possible, so that payments are made to recognise that suffering and that stigma and shame that individuals had put on them, unjustifiably so. I think we all want to see that made right. But I am curious as to your experience of how well understood, because it is complicated. How well is that understood in terms of that the initial payment would be simply a payment to acknowledge that they were impacted by this and admitted to one of the listed institutions?
I think there's relatively good understanding of the two parts of the process, and I think that came across relatively clearly in last week's session. Sandra and Ciara may say something about individuals that they work with and the level of awareness they have of that. I think what becomes quite complex, and that again was evident last week, was the quite confusing position around the different terms used for redress and used for the inquiry. So we have prescribed institutions versus relevant institutions. We have relevant persons, eligible relatives. So that does become quite cumbersome, and we understand why all those terms are there, and it's two different processes doing slightly different things. I think that was generating quite a lot of confusion, and probably continues to do so, and maybe we can think about ways to get that message across a little bit more clearly about the difference between inquiry, redress, who is eligible, and then that point of eligible relatives as well, which is quite important and also quite probably confusing. In terms of general awareness, I don't know, Ciara or Sandra, if you have any comments about those that you work directly with?
I wouldn't disagree. I think everybody that we're currently engaging with, which is almost 300, understands the difference between the standardised and the individually assessed payment. It's whether or not they see themselves within it is the issue.
And maybe a level of concern about what that next stage will look like, and how difficult and traumatic that might be to go through that individualised payment. All of that, not underestimating how it may well be difficult and traumatic to go through the standardised payment, just engaging with this, whilst it will be a very straightforward scheme and process and application. It's the subject matter of for the first time potentially putting pen to paper on something in this area will probably be difficult, and that's again why it's important that we take the approach that we are to support people with their applications. Not everyone will want to sit down and do this themselves, and if you want help and you want the wraparound support that comes with it, we need to make sure that the model is there and that the resources there to do that from day one.
I appreciate that, and clearly I don't think anybody wants any more trauma or any more suffering to take place, so I think whatever can be done to make these processes as smooth and as easy as possible is something that we would all desire. Just finally, just ask you if you've any kind of practical suggestions as what can be done in terms of looking at that problem of accessing records. If you've any practical suggestions of things that could be done to actually to make this much easier, because that's traumatic in itself. And families are very, very complicated, and some families are way more complicated than others. It's not easy, and working with individuals can be challenging because we all have different views and different needs, and we all react differently to different things. And we see so many times amongst groups and charities and churches and how people can almost war with each other over trying to have their needs met. So if there's any practical suggestions that you have, to, even in terms of that access to information.
Well, I mean, sorry, go ahead.
Go on ahead, Andrew.
So no, I mean, I was just going to mention one thing and then pass to you, Ciara, around the specifics. But yeah, that point I made earlier around support for our colleagues in the health and social care trusts to have the resource they need to meet the requirements that are going to be placed upon them as more and more people come forward and look for records, you know, fairly soon. And I think probably we're seeing the starts of that already. Ciara reports that more people are coming forward in advance of these processes to try and get records that maybe they haven't done before. And when the scheme comes out, it becomes even more clear about exactly what's required for redress and for understanding your own story for engaging with an inquiry. That will lead to a greater demand on the really stretched services that there are at the minute to release and provide those information. I don't know anyone else practically, Ciara, in your work.
I think an open dialogue across the relevant departments here, really, where resource might be needed to alleviate the shortfall that currently exists and will only increase really as numbers increase and come forward.
Appreciate that. I suppose, Chair, that is a real concern. We're all very aware of the pressures on the health service, and even with a big massive pot of money injected tomorrow, you can't magic out of there that capacity and that professionalism as well. So that is a real consideration too. Thank you.
People in capacity, even more so than.
Can I say that one thing that I think that resource is needed now? It shouldn't be next year, because if it's next year, you're already too late. You know, because people are, and that's one learning I think from the TPDPS in relation to access to records, GP records, police records, all of the various things that came. That actually there should have been much more preparatory work to be ready for when TPDPS opened, or HIA when it opened, to be actually ready for what was coming. So that resource impact, I think, needs to be looked at as a matter of urgency if you're hoping to meet the deadlines later on for next year.
And I think whether someone's eligible or not, they're going to need to come forward to access their information to see if they're eligible. So regardless, it's going to impact on the resource as it stands.
Thank you.
We're a couple of minutes short of our allocation here. So, Ciara, I'm just wondering, could you maybe give us an update or an overview of the DNA service? That'd be useful, especially for people watching online.
Yes. So, as part of the Truth and Accountability report, it was a request of victims and survivors that they had access to voluntary DNA testing. Mm-hmm. And I suppose the simplest way to put it is that somebody can go and buy a DNA test and go and do it themselves, but from personal experience it's just not that straightforward unless you do a very close match to say this is your direct relative. So we set the service up to sort of complement standard tracing and genealogy that we would do to meet an objective of finding a birth parent, for example. And it's done and safeguarded in a way that we try and meet that objective without then alluding wider family members to the fact that there's this person in the ether on their family tree. So the individual will have full support through our advocate and access to the genealogist and genetic genealogist within Adopt NI to interpret the results. It's quite a timely endeavour for one individual, depending on the matches that they get, and it goes alongside your standard, what I would call paper-based genealogy, and then the wizards in the team who look at the genetics and the interpretation. So there's been about 46 people to date have engaged with that, and largely we've had positive outcomes in terms of 43 people, and out of the 43 we've had 30 successful cases, and when we say successful, that's in 25 of those cases we've determined a paternal or maternal direct link and been able to offer the person an intermediary service or choice about whether to progress that with their relative. In some cases we say it's successful in that we're able to identify grandparents, but it could be a grandparent on the maternal line with 4 sons. It's very difficult then to define which one of those is the birth father, but it still gives that individual that little bit more information, and you can begin to paint them a family tree. And in some cases it can confirm or refute information that they've already received from Statutory, so it's a complement to it.
So thank you. Just one last question. It's free, isn't it? It's a cost.
Funded through. Okay.
Yes. This is part of the model, and it was set up as a pilot. It's been fully evaluated and now is rolled into the sort of the standard services. So I think we've provision for, is it 75 per year?
Yeah.
But I mean, we'll be flexible on that as we work through and scale up the services. Yeah.
Brilliant. Thank you so much for that, and thank you for all your work in preparation for coming today. I really appreciate it. Okay, members, thank you. Just take your ease for a minute while we just change the panel. Just going to ask the clerk if there are any actions to recap on.
Thanks, Chair. I think there were a couple of things that the witnesses suggested they would send through. So Wave said that they would send through some case studies and adopt an I also case study on access to records and experiences on the past of that. I've noted down a couple of other areas that were covered that aren't actions as such, but obviously budget and lead in terms of the promotion of the scheme once it actually becomes live, and also something for us to think about as we move forward is terminology within the bill. Quite a number of people have raised that it can be a little confusing, but I don't think there's an actual action out of that today.
Okay, thank you very much. Go ahead, please.
We need to get to a point where we're putting in the bill that there is an advertising budget to make sure it's sufficient and it's fit for purpose. There's all this maybes and ifs and buts, may language, but we need to, as a committee, have something nailed down that, we're content that there's going to be a fit for purpose pot of money to reach people that's entitled to this. That was on the advertising. The sharing of info, I got the impression it wasn't sharing the records, it was sharing general information. Is what I don't know if it was an off-the-cuff remark that Andrew made, but that's certainly something that's concerned me greatly, that you might have somebody that's come forward eligible for the first payment, but if that information isn't shared with them when it comes to later on the further payment, it puts them at a detriment to have a successful application, and that's something that really concerns me.
I think we'll maybe need to get legal advice around the clause around the budget. We could definitely put it in our committee report at the end, and we could maybe raise it now with the GO officials coming forward. I'm going to bring Sinead in, and then I'll bring the panel in. Go ahead, please, Sinead.
Thank you, Chair. I was just concerned there at the very end in relation to the resource issue with the HSCT, and I think it would be appropriate for us to contact them because they will need additional resources, and when the records are actually found and given as well, they can be very complex, it can be very traumatizing for those that are receiving the records, and that will put additional pressure on WAVE and VSS and Adopt NI as well. So it's a wider resource issue, and I think we need to get ahead of that, and so we probably should make that known to the HSCT, please.
Okay, thank you. Go ahead, please, Pam.
I was just wondering, would it be appropriate for this committee to write to the Minister of Health as well to ask about what preparation is in place? Given what's being said by the witnesses today, that really, it's needed now. It's needed now. It's not a matter of wait and see. We know that we're understaffed in so many areas, and I think the very least we can do is support people through this process.
We have already in preparation for this. I wonder if maybe could you share that response then? Yes. But we could maybe keep this under review. Yes. Okay, members, I'm going to move on just to our next item there. So we've item 7 then. So we've got our departmental officials coming in to speak to the bill, and just want to seek your agreement again for Hansard to record the session. Great. Okay, thank you. Okay, members, going to refer you to pages 60 to 62 of the pack for the clerk's brief, and pages 134 to 163 of the pack for the Executive Office's response to correspondence from the 24th of June regarding bill queries. And I'm going to welcome to the meeting Martin Carey, the Director, Truth Recovery Programme, Francesca Murray, Head of the Inquiry Team, Elaine Allen, Head of Redress Team, Michaela Jordan, Head of the Programme Team, and they're obviously all from the Executive Office. So just to remind members that we forwarded 12 queries following last week's meeting, and officials have asked could they split the 12 questions into 3 sections during this oral briefing today. Each section will cover 4 questions, and we're aiming for less than 5 minutes intro per session. So then we'll go on to questions. So just finally then, the clerk emailed members with the areas to be covered in this section earlier today. Okay, thank you. Thank you so much. I'm just going to invite you to brief for members.
Okay, thank you, Chair, and thanks, Committee. As I said, we'll just run through 4 questions at a time. So I think the first question was really about the joint working of institutions and what information is available in relation to this. So this is really covered under Clause 2.2 of the bill currently. So I suppose all the evidence we have from the Queen's and UU report is that there was clear networks or groups of individuals, professions, organisations, institutions and state working together. So this is tried to cover in terms of pathways in to institutions, what happened to people whenever they're there, and specifically 2B looks at the state's role around registration, regulation and inspection. And then Part C is about the placement and departure of children, and that will include, so I suppose in the EFM on page 6, we've outlined what do we mean by public bodies. So that includes agencies, it includes basically legal and medical structures, and it also includes social services. And then also on on page 6 of the EFM, in terms of other persons, it outlines GPs, clergies, social workers, baby homes, private nursing homes and businesses. So those are a sort of good example of that network or joint working. I think this has been a feature of the Queen's UU report. It will be a feature, I'm sure, of the independent panel's report, and I'm sure it will be a feature of the public inquiry. So that's just a short outline in that joint working.
Yes.
So.
Okay.
I'll go on to question 2. So question 2 was really about what provisions there are for individuals around legal representation. So this is really covered, the broad principle or power is covered in 21.2 of the bill, which is really given a power to provide expenses to witnesses. So that's about legal representation. The detail of how that will work in practice will be in the rules, so that'll be 27.1c. But I suppose just to provide some assurances, individuals who want to provide evidence or oral statements to the inquiry will be provided legal support, and there will also be a core participant status as part of the bill as well. So we're not completely sure how much that would be, but it would be in the millions of providing legal representation and support to victim survivors. So that's question 2. Question 3, which I think came up last week, but also I think is a theme and some of the engagement we've had with victim survivors since the launch of the bill, was particularly about the emphasis on cross-border movement and what information is available in relation to this. I think the Chair, you referenced last week about the MOU with the Republic of Ireland and OMA. So I think just first of all to say that I suppose there's a north-south element to this, but there's also an east-west element. We know that there are practices where individuals or institutions were not only moved north and south, and there's particular case studies around Fawn and County Donegal as an example, and we've records through Prony and the independent panel in relation to Fawn. But there's also east-west in terms of Scotland, England, Wales, and movement from institutions here to GB. So I think the first thing to say is Prony have good engagement via the independent panel structures with the National Archives in the south and TUSLA, and there's some data sharing agreements that we're trying to put in place, particularly from some institutions that are held privately. So Stamullen and County Meath is an example. So the cross-border element is technically covered within Clause 2.2 of the bill, but appreciate that this is it's not just about cross-border, it's about cross-jurisdictional as well. So that's question 3. Question 4 was really around compulsion. So the bill at this point in time is effectively silent on compulsion of contributions, but I suppose that doesn't take away from the broad principle that I think ministers, executive, and I'm sure the committee share about those deemed responsible should be making financial contributions. I think there was some discussion with the researchers, and I know there's separate legal advice that I think the committee are receiving in relation to that, but just around how and when. So that's just that commitment around contributions is clear. It's just how that would operate in practice. So I'll pause there, Chair. Okay. So happy.
Thank you.
Thank you.
I just want to pick up on that issue around the memorandum of understanding, and obviously we've seen the legacy framework coming forward. We haven't seen the text of the bill, but just while we're sitting here, I've got a message from one of the birth mothers, and she'd been sent to Bernardo's in Dublin, for example, to access her records, which really isn't great for somebody who's already been traumatised. I'm just wondering, could the conversation progress from a memorandum of understanding to actually the Irish government bringing in their own legislation around providing? Has that conversation started?
Yeah, so I suppose there's a couple of elements of key legislation. So in March 22, there was a provision brought through the Assembly, which was a preservation of documents. So that placed a protection, and it made it an offence for institutional records to be moved outside jurisdiction, but also protect the records that are in place. That legislation has now been replicated in the South. So that provision was introduced, I think, in November of last year, which was a positive step. I suppose, Chair, there is that distinction about individuals. It's easier, and I'll say that loosely based on the discussion we've just heard from VSS and Adopt NI. It's easier for individuals to request information here if it might have to be separate processes then to request similar information in the South. So I'm not saying our process in here is not perfect, but it is requiring individuals. Now, there's lots of support that Ciara and her team around support and advocacy work to help people through that process, but it's a work in progress, sort of how I would describe it. So.
Thank you. Sorry, I was just checking there. This is a new list. Carol, please.
I may come back at a different stage, but when we spoke about the power to compel the institutions to pay, I mean, see, even under clause 36 to clause 37. So if you look at the power to disclose information, and then clause 37, it talks about payments. I mean, I'm not saying that you have done this deliberately, and I just want to be clear on that. But when you see sentences like, you know, about payments will be made and treated in relation to certain means tested benefits, and the institutions who were responsible for this aren't even mentioned anywhere, it just seems to be, we may take some of your benefit if you get a payment, but the people who caused this misery aren't even mentioned anywhere in these sections. Is there room for an amendment so that the power to compel to make a payment will be put in by the institutions?
Yeah, I suppose we've looked at options and what options are available. Carol, in relation to that, I suppose one of the challenges we've been trying to work through is what legal basis do we have in order to put a power to compel within the bill, and I suppose it brings in actually some quite complicated legal processes around basically something called Article 1, Protocol 1 about a person's right to property. So it's just about, the bill is effectively silent at this point, and I think it's important that we have the opportunity to bring the bill into the Assembly. That's not to say that work hasn't stopped, but it's just trying to work through.
No, I appreciate that, and I think we all do, but the issue for us is that you can engage Article 8, you can engage Article 13, you can engage all the different articles. From a position of the committee, we feel it's just not just for the institutions for any attempt to compel them to pay. Now, whether they have the ability to pay is down to the inquiry, but they should be at least compelled to pay.
Yeah.
Because, and if there's any attempt to sell off or hide assets, you know, I mean, if you were responsible for causing damage to one of the pillars out there the front and I was liable for it, and it cost £10,000, but really I can only afford 1,000.
Yeah.
I mean, there needs to be some sort of attempt for this is part of redress as well.
It is, yeah.
So I think I would like to see something, and I understand you can use whatever piece of ECHR not to do this.
Yeah.
I'm not saying you're doing that.
Yeah.
But equally, there's articles within ECHR to do it.
Just to remind members, we have asked for legal advice on this, and that we're going to get it presented in closed session next week.
Well, that's fine, but it would be great if the department could bring the amendments forward rather than us having to do it.
Okay.
I'm happy to provide a short response on that.
Yeah.
I suppose one of the things we've looked at, Carl, is we really have tried to examine what's been done in their other jurisdictions as well, and what options are available as well. I mean, we haven't been able to find anywhere that basically hasn't used a voluntary basis for contributions. So that's not to say that we can't explore options, but it's just at this point, I think the bill is silent on it.
No, and I appreciate that. And we've had Paul Sweeney, who up until now has tried to get voluntary contributions from the orders and institutions, and at least there's an attempt by the department that in good faith that there was intent made to go down a voluntary route.
That's right.
We received correspondence from one of the institutions, really offensive, saying it actually cost them money. Yeah, so I think we were all kind of astounded by that, but at least the department has examples of where in good faith it's tried to go down a voluntary route, and there's nothing as committee members that we've heard that would indicate that the institutions are acting in good faith. And that's why we feel compellability needs to be in the bill.
I suppose the challenges that the Republic of Ireland have faced have been the same. So they had appointed an independent negotiator called Sheila Noonan, and she basically brought forward or engaged with 9 institutions. Only one institution provided a meaningful contribution. So I think they're exploring options around that as well. So.
Okay, thank you. Timothy, please.
Thanks, Chair. Just following on the same vein. So essentially the redress payment is an acknowledgement payment. And I see no reason why the institution shouldn't be paying a portion of that, if not all. Like at the end of the day, it's an acknowledgement they have been in that home, that institution. And I haven't heard anything to date apart from no other jurisdictions done it and we're looking at best practice and this, that and the other. I'm not interested, we've got to the stage now where we've tried talking to these people. There's nothing coming back, so I'm not interested in what other people are doing, I'm interested in what we're doing. And I believe if the department doesn't come forward with something, this committee, based on the legal advice, there's a unanimous feeling in the room when we talk about this, that the religious orders and institutions should be held accountable for the money that this is costing. I've heard tell of, well, in phase 2 it might be easier to get them to pay. No, I think we need to be looking at redress as first payment, because that ties somebody to that home, ties them to the responsibility, and we need to do all we can. The department needs to do all they can in leading this to make sure that we have something in this bill that means that they will have to pay. If they have assets, they have to pay.
So, just to respond, I think that it's definitely easier after the public inquiry, but I take your point that it shouldn't, and I don't think that's either the intention of Minister's Department to just leave it to, I think we're looking at every option, Timothy. It's just how doable some of those options are and what assessment we need to do and how that's reflected in any, whether it's in this bill or a separate process. So I don't think, Timothy, we understand, back to Carol's point, this isn't just about a sort of financial contribution, although that is important. It's about sort of a restitution or a redress element.
There's an acknowledgement on behalf of those that caused the harm that they are paying towards this. And that's what's more important than any financial payment that the victims will receive. Moving on then to the legal costs. Just to expand on that, so there is the expectation, we've got it confirmed from yourself, there will be costs covered. Can you expand out? Will there be a list that essentially have solicitors to work off, or will it be a case of Joe Bloggs uses their own solicitor and the expectation will be that will be paid? From looking at this, I think we have again the words may in there from memory, and I think people need to have that assurance and that understanding that if they have built up a rapport with somebody over the years and trust that person, they're confident of theirs, that they can use them to help them along in this process. So when it says was it 21.2, the power to make an award under this section includes power where the chairperson with the approval of the executive office considers it appropriate. You know, we need a clear set of rules or a clear understanding of, no, if somebody wants to go to their solicitor, they will get financial help, instead of hiding behind with the chairperson with the approval of the executive office. Somebody needs assurance that if they're going to give evidence, they're going to incur legal expenses, they need to know that from the get-go.
Yeah. I'll maybe let Francesca answer, and I'll maybe provide how this has worked in practice in a recent inquiry, Timothy.
Yeah.
So,
detail of the legal expenses and how they will be managed and paid will be done through the regulations themselves, so that will all be set out step by step within the regulations. The regulations themselves will be consulted upon, so people do have the opportunity to feed into that and say what they think. There are several different models out there that people can potentially go on an individual basis, or the group model where solicitor can provide the services within specified groups. Say, for instance, in this case you have a number of different victims groups, they may wish to go in a group model or whatever, and that would be expanded that way through the core participants, or even would be support for someone to provide a witness statement, so that would be supported through from, you know, the very start to the end of the signing of the witness statement. So those, it is envisaged that that would be within the regulations, and how that would be set out in the regulations. But again, that's subject to consultation, and people do have the opportunity then to provide their views on that too. But
when will we see any of that?
So the regulations, Timothy, we're hopefully planning as we get to probably final stage, a final vote, then we would like to consult potentially on the regulations before royal assent, so that that's a sort of, and I suppose a key aspect of that is views of a chairperson as well. So I'll just use an example of a recent public inquiry where they had individual victims groups that were basically put forward sort of proposals on who they wanted to represent them. So that was one model, and I think there was a couple of local legal firms who basically represented quite a big, like maybe not a majority, but close to a majority. But there was a third provision, Timothy, for individuals who basically weren't affiliated with a group, didn't have that there was a separate legal firm that was available for them to provide their evidence or to support them through the inquiry. So there's a couple of different models around core participants, but that will be consulted on as part of regs.
okay, I'm just going to put it on record. We've got the standard statutory rules coming in later, and we will be talking about the secondary legislation in that session. Philip?
Thank you, Chair. Just firstly, for my ignorance for not previously being on the committee, but what did the question mean whether officials have considered the Bomb Inquiry Memorandum of Understanding?
It's just, I suppose, Philip, the bill in here around, let's say, powers to compel or data sharing, those are stronger, if you like, within this jurisdiction. But I think in the Bomb inquiry, there was an intergovernmental arrangement that, let's say, government data was shared between the two governments. So just trying to put in place similar arrangements, that particularly if there's an institution of interest, so Stamullen in County Meath is maybe a good example of where some of those records are held by the state in the south, so that we've got that sort of a protocol that can access those from an investigation perspective.
Well, if you're looking for a good example, that's probably the one that you want to avoid in relation to that Memorandum of Understanding with the Irish Republic, given the fact that there's no ability to compel witnesses, no ability to compel information or document sharing. So if you want to have a failed process, you copy the current Memorandum of Understanding with the Bomb inquiry. I just want to pick up on Timothy's point in relation to Clause 21, and he highlights a really important issue. In terms of the regulations, will they be subject to draft affirmative procedure by the Assembly?
They're definitely subject to
Not them all.
as a draft negative.
Not them all. 27.
Sorry, 27.
Clause 27, clause 32.
It's negative.
They're negative resolution. They'll need to be affirmative.
So I think that Timothy and Carol highlight an important point, that these regulations are going to be so important and so serious that it would be important that the Assembly have an automatic say in this. So I just think it's something that officials should look at. I just want to pick up on the point that both Carol and Timothy made about silence on compulsion for the institutions to pay. and the view from the department is, right to property. So I deal with constituents on a daily basis who can't afford their private rented house and they're evicted. There's no human rights coming in to save their house. They're put out onto the street. If they don't able to pay their housing executive rent, they're evicted and put out on the street and have no recourse to any further public funds because they've made themselves intentionally homeless in the view of those institutions. So I don't see how we can use this as a protection to protect institutions who engaged in wrongdoing, but we can't use those legal protections to protect our own constituents. So I think the department really need to have a proper and full look at this, because although I'm only new to the committee, it seems clear that they'd want to come forward with a clear amendment that puts the pressure and legally requires them to come forward, because, as Carol articulated, if we engage in wrongdoing and are found guilty of doing so, we have to pay for it. So I would encourage you to do it, because ultimately you're going to end up with a committee amendment. It's going to be better coming from the department.
I just would need 3 more panels to get through. Go ahead. 3 more sections of this panel. Sorry, go ahead, please, for the next series.
So, number 5 was really around access to information. I think I'm happy to go into a bit more detail, just and maybe following on from the evidence provided from Andrew, Sandra, and Ciara. But I suppose what Clause 16 really provides that power to compel evidence and documents, and then Clause 35, and I think we've talked a little bit about redress, and that's basically the ability to access it, bring information in, and then share it with third parties. So we could have that scenario that in that last process, that, and it's a scenario we want to avoid, that information, an individual doesn't have access to information that the redress services has access to. That's something we absolutely want to avoid, but that is just, there is a sort of quite a complex process around mixed data. So basically, if an individual belongs to more individual. So I'm happy to provide more detail, but I'll not say much more on that question just at this point. I suppose the question 6 was then around the difference between a relevant person and an eligible person, and I suppose it's absolutely right, that was what was raised last week, that you could have a relevant person for the inquiry who may not be an relevant or an eligible person for redress. So you could have a scenario that you have a wider set of people who are relevant for the inquiry and a smaller list of people who are eligible for a redress payment. So that's just to confirm that that is the case, and that's outlined, and I'm happy to go into again more detail on that, but Clause 4 outlines who is a relevant person for the inquiry. And then Clause 31 outlines who is an eligible person for redress. And I suppose as we go through this, the individually assessed, you might find that that individually assessed payment then expands again. So it's just trying to provide that sort of framework. 7 was around definition, terms of reference, and scope of the inquiry. And I think there was a lot of evidence heard in relation to this, but what the inquiry seeks to provide in terms of the bill in 2, 3 and 4 is really a framework for an investigation, and it outlines the institutional types that will be investigated, and that includes pathways and practices in and out of institutions. I suppose some victim survivors would have a view that this should be much wider, should examine the wider sort of adoption and foster system. So those are sort of considerations that have been taken into account through the sort of consultation process, and we've tried to provide some assurances, but I appreciate it's not going to provide all the assurances to everybody at this point. I'm not going to go into lots of detail because I'll leave time for the questions on that. I suppose the final thing in this block was just about some of the evidence around young birth mothers and about whether they would be included or relevant for the inquiry. I suppose the inquiry doesn't have any age parameter, so we're not making any restriction on age. So if someone, for example, had provided evidence to HIA and they're relevant to this inquiry, they absolutely are included in the inquiry here, and that also applies to redress as well. So there's no age parameter for young birth mothers, so that's just to provide some reassurance around that. So I'll pause there, Chair, because there's probably quite a lot in those 4. So
yes, thank you. I suppose I just want to pick up on the issue around deceased babies and at one of the familiarisation sessions, for example, there was a woman there whose sibling died within hours of giving birth, and I suppose they felt that the bill, they didn't really see their relative on the face of the bill, and I'm just wondering if you could speak to that.
Yeah. I suppose in terms of the inquiry side, we've tried to frame relevant persons as any persons, and that would include, unfortunately, if a child did die at childbirth, so that would be an experience that we would want to capture as part of the inquiry, and that would include basically their treatment and care, how they were, what happened to them after they died. So I think obviously this is a very emotive issue, but just to provide that reassurance, the inquiry will seek to examine particularly infant mortality rates. It's sort of from the previous research and evidence and inquiries, that's an area of interest around infant mortality rates, and that will also extend into burials and unmarked graves.
Okay, but is there anything within the redress then, in terms of
at the redress at the minute, it is if it's exclusive to basically they wouldn't be eligible for redress
under
the current provision. Yeah,
with the posthumous date, basically.
That's right. Yeah, that's right.
Okay, the other aspect of it is the, I think you just mentioned it there, around the burial sites and our unmarked graves. Is that pretty much outside the scope of this bill as far as you can, as far as the Executive Office is concerned?
So it's absolutely relevant to the inquiry, and it's really covered under 2.2 of the bill in terms of departure or placement. So that, I know I'm using that sort of phraseology loosely, but it's basically, I suppose we're interested in terms of if a child died in infancy, where were they buried and what examination of their experience is available and what evidence is available. So there is some provision that the bill could absolutely commission geophysical surveys. There is powers there for an inquiry chair with sufficient evidence to commission geophysical surveys. There is a question I think that was raised at committee previously is about, at the minute, that provision would have to be done with a landowner's consent. Mm-hmm. So what happens if that consent isn't available? So we are trying to get some additional legal advice just on that particular issue.
I think Francesca's trying.
Oh, sorry.
I know there's also the power to compel obviously the death and the burial record, so we could the inquiry will look to see how those match and how that there's maybe any disconnect between those, and if there is a disconnect, why is there a disconnect, and that'll bring that to the fore as well. So although it doesn't look like it's in the bill, it is sort of segued into the bill in that sense, so it can be covered.
Maybe something for us to consider, maybe in terms of some amendment in terms of the wording or something. Okay, thank you. Timothy, please.
Just a couple of ones to pick up with you and come back to the compelled disclosure. Very, very important for records, but it's just picking up on that last session again about information not shared with applicant, and you have briefly touched on this. And you had said about it being mixed.
That's right.
Can you expand on that so I'm clear on what the comment from the first session may relate to?
Yeah, so I suppose, Timothy, if let's say if an individual is adopted, they will, at the minute what happens is they would go to Health Trust and they'll be basically assigned a social worker who will basically go away and get their information. So that's how the model. So they might come back with a 20-page adoption file. They could come back with a 1-page adoption file, or but some of that 20 pages may hold information which also relates to another individual. So that
if they were adopted twice or something.
Yeah, or basically a birth mother or a sibling, or so it might hold information about more than just them. So then that has to go through a sort of practice guidance. So a social worker has to go through, identify which elements are disclosable to that individual, and there's lots of balancing tests that have to. So some of the considerations is if the person is still alive, then there's a disclosure that information could be included and disclosed to the individual. I suppose, Timothy, one of the issues that we may have as we go through the redress process is that an individual might come to us with an application and we have to verify basically that they were linked to their mother's admission. So how do we do that? So the redress service may be in a position where ideally an individual would provide some of that information to the redress service and they would verify that, but we could be in a bizarre scenario that an individual might not be able to access that information but the redress service could. So that it's just that differential in terms of a redress service might actually be able to get more information about an individual than the individual themselves.
Just for clarity, regarding their time in the home, what they experienced, there'd be none of that information should be withheld, which would impact potentially their phase 2 claim against.
So it would be up to the individual to decide what information they want to receive. So some individuals will choose not to access information about their experience, but they may wish to put in an application for redress. So I think
it's not the information they may choose to receive, it's the information where they don't have a right to see. That's where my concern is.
So if, I suppose, for the second stage, the individually assessed, Timothy, the basic principle would be if individuals have received information about their own personal circumstances, that could be used then in an individually assessed under a statement of experience model. But we don't know what the individually assessed scheme will look like at this point, but that would be, if that was to follow other processes, you would basically, individuals would receive that information and then that would form part of their statement of experience.
My concern is that the individual doesn't get all their information.
That is a risk.
So that, how do they know what's in that information, whether it would be useful or not to phase 2? And I know we're still working out what phase 2 would be, but my concern is that there'll be information withheld from them which will make their case for phase 2 weaker.
Yeah, that is a risk, Timothy. That is a possibility that an individual may not have all the information about their own circumstances in order to put in the best application possible under AAP. So some of the mitigations around that are around basically the practice guidance and how people access information, and there might be other options, legislative options, to support that as well. So I don't know, Elaine, have you?
I think it's probably important to clarify that for the standardised payment, we don't want people to go away and gather a lot of information. That is not what is needed. But in order to put an application in, it's based on the mother's admission if they're not the mother. So for example, a birth certificate may be needed. They need to know who their birth mother is, and there's where the problems may arise, and to enable them to make an application they need that information. Now the redress service does have the power to compel, so in essence you could then be looking at something that the redress service may be able to get that person can't get necessarily, or can't get it quick enough. So it's about looking through what potential problems there could be with the power to compel versus what an individual has. So, there's just different things that need to be worked through. It's not that the redress service aren't going to have, it's not anticipated that the redress service will have reams and reams of information on a person that the person wouldn't have themselves. All the redress service are doing is verifying the admission. So obviously it'll be up to the president of the redress to determine what that information is, whether it's, a log of somebody being admitted or just confirmation from somewhere that they were admitted is up to the president. But the plan isn't that an individual has to go out and dig through a lot of information, try and get information. That for the standardised payment, that isn't the case. Now, when they're making their application for IAP, which we don't know an awful lot about, but it's going to be harm-based, the information that they want to gather to put in their IAP application is entirely up to themselves. But for the standardised payment, it's not expected that the redress service will have a lot of information that the individual wouldn't have, but it's just in case there are circumstances where that might be the case that we need to work through that before the scheme opens.
But my concern is that redress is able to get a lot more information than the person is. So then to be in the best position to put in, do you refer to it as IEP?
IEP, yeah, individual.
To put in their application for IEP, there's information they're not entitled to.
That's a potential risk, Timothy, that you could have individuals who there's maybe information that could be relevant for an IEP that they actually currently can't get access to.
Redress could.
For redress, yeah. But the redress could, yeah, potentially.
But as it stands in this legislation, the redress service are only going to be compelling the information they need for standardised payment. So if you're thinking ahead to the individually assessed payment legislation, if that had the same power to compel, then yes, we are in that situation. But at the minute, it's not it's obviously we're working through if there are any issues in terms of information the redress service could get that an individual couldn't get, but because it's designed to be a straightforward process, there shouldn't be a huge area of risk there.
Okay, I'm just conscious of time. Carol, please.
So going back to restrictions, so go back to clause 15 to clauses 16. So my concern is that the use of public immunity, and so just to be clear, I have no issue if someone's coming forward as a whistleblower.
Yeah.
They need to be protected, but I have an issue with institutions being protected. I think that's grossly unfair, and I understand, just looking at this, that this is from the 2005 Inquiries Act.
That's right.
So I accept it was done in good faith,
Yeah.
again, but I do not want to give anyone the ability, because I think the people, as part of their redress, they need to see and they need to hear. So that's one thing. And are the department considering the amendment, as I've asked before? And then the other aspect is, so it says that the chair has the ability to decide information or published information on clause 17. So it becomes a bit garbled for me. So see, when it comes to privileged information,
Yep.
and particularly if it's in relation to redress payments, or if you go further, how are they going to get that if it's not clearly laid out? Because to be frank, I imagine people looking at this, the AFM,
Yeah.
would even have difficulty trying to find a way through all this.
Yeah, I think I'm not sure if that's the bit where it references an assimilated obligation, which is not the most, accessible at times.
I don't even know what that means,
exactly.
Martin.
Well, so I suppose that sort of it's really around retained EU law. But I'm happy. I think the principle that you're making is that 17.2, in particular, so 17.2 is basically a public interest.
15 and 17.
15. So 15, I suppose, what the
16, 17.
Yeah, the 15 in lots of ways is about as much to protect sort of victims, survivors, and
I understand
confidentiality.
that.
So it provides, basically, 15 is really about protection of if information that has been provided in confidence by particularly victims, survivors. Public inquiries generate, this is restriction orders are used. That's what that clause 15 is there and aim to do.
Can I give you an example? So in the south, a woman didn't know she had a twin brother.
Yes.
But Tusla had that information.
Yeah.
And then the Irish government see the records.
Yes.
And I can't get access to them.
Yeah.
So, and her twin brother died.
Yeah.
So she found that out incidentally,
Yeah.
or accidentally.
Yes.
And, I just think that's so insensitive.
Yeah, of course. And I think, Carol, as evident, I suppose that in terms of particularly what an inquiry chair discloses about powers of discovery, and that's particularly where a core participant or individuals, there's going to have to be a very controlled process about if information comes into receipt the inquiry, how that then is disclosed to individuals, so that sort of power of discovery. I think, Carol, on 17.2 about public interest immunity, we've taken more advice on that, so I don't have a final sort of view. We've tried to look at where it's been used in other inquiries, so it's pretty limited in what we've seen to date. It primarily has been used in national security, but it also has been used, I think, in relation to if I'll not use the phrase whistleblower because I think there's separate legislation. It has been used maybe around if a crime has
Protect witnesses.
If crime has been reported. So we're just I can't provide a definitive view on that, but we are looking at it. So.
Just to confirm, our legal advice would also ask for that around.
What's fine, but even just to say, like, we've raised this. See, and that's my last question. See, to talk about the regulations, are they going to be done before further consideration stage of the bill?
We thought we'd probably do the regulations after the final vote, so but before royal assent. So
Is there really putting a lot of emphasis on the fact that you're expecting us to trust? I'm not saying we don't trust you, but there's a big leap of faith here, because we want to make sure that the regulations, if it's not in the face of this bill and if it can't be amended, and you're giving us the assurance it'll be in the regulations, I would like to see, personally, I think we all would like to see the shape of those regulations before we go, because it is a democratic process,
of course,
and we're open to scrutiny.
Yeah.
But we don't want to let any of these victims, and I know you don't either. But if we're relying on what's not here, being in regulations, and it's not there.
So I think, Carl, the intention is to go out to public consultation on both the inquiry rules and the redress rules as well. So that is the intention as well.
Before further consideration?
After probably the final vote.
Okay.
Thank you. Okay, section 3, please.
Okay, yes. So look, I think 9 was really around clause 31 in general, and I'm not going to go through all of that, but it's basically posthumous claims and eligibility, and I'm happy to take individual sort of queries on that. But I suppose just to reiterate around the posthumous claim, and we've tried to, and we acknowledge that this is obviously one of the most sensitive areas of the bill, and you've heard lots of feedback on the posthumous date, and we've heard similar feedback as well. So I suppose just to reiterate what the posthumous payment is tied to, so it is tied to that basis of expectation at when an expectation of redress was created. So through the public consultation, it was November 21 was the sort of most obvious date, and through the consultation it was moved back 10 years. We've looked at lots of other schemes. I suppose this is a gender-based scheme. It's trying to provide redress to people, women and girls who were admitted into this institution or institutions. The only two international comparisons that we have really are the Republic of Ireland, who had a different approach. They basically provided redress, yes, to people admitted. Children over under 6 months were excluded from that process, and their posthumous date was January 21. And then the only other one is really a scheme in Victoria in Australia, and they had provided us £15,000 or equivalent of £15,000 payment to birth mothers, didn't include children, didn't accept posthumous claims. So that's just contextualising. I suppose we've tried to develop a system that provides as inclusive and as many people to receive redress as possible. So I'm not going to sort of work through all of the questions, because I'm sure there will be questions just on that. I think the shelter and maintenance just aspect of 31 was just really about that private patients experience, particularly in Thorndale and Malone Place. So it's specific to Thorndale and Malone Place, that sort of private patients element. And I think we've covered question 10, which really the network of institutions. So just in the interest of time, I think that was covered in question 1. In terms of foster care, which was I think question 11, and basically foster care is included in that if an individual was in a mother and baby institution, a laundry or workhouse, and the pathways or practices out, and one of those practices out may have been into foster care, but it doesn't include an individual or the entire foster system. So that's just their current policy is it's very much about sort of institutions and their pathways and practices. So it would include individuals who were in institutions who end up in the foster care system, but it doesn't examine the entire foster care system. And then the final thing, and then I'll stop talking, is just about birth fathers. And I suppose just go back to the original policy intent that we had as part of the public consultation, and also as part of the EFM. This is very much about a gender-based women and girls. These institutions didn't exist for men. So, and absolutely understand sort of that sort of parental loss for birth fathers in many cases was the same. But this is very much focused on that sort of gender-based admission to mother and baby institutions and laundries and workhouses. So I think that's sort of the key sort of considerations around birth fathers. So.
Okay, no, and I think that's probably just something that's clearing up, because when you saw last week, some people thought, yes, no, that was right.
Yeah.
So I think it was just something we just wanted to raise. I suppose I think we're all going round the houses again on this, Martin, but just to put on record, I don't care what other countries have done in terms of their redress scheme. We have had 10,000 women plus go through these institutions.
That's
we
right.
have lived with the shame and stigma around this. I think we need to develop something that fully recognises all the women and the children, adult adoptees, who've gone through these institutions. So I understand that, and the paper I think you sent last week indicated that there had been some inspections in the 1960s or something. So it was years ago.
Yeah.
And that was part of the justification that set it aside against the institutions, the HIA institutions. But we know whenever there was an inspection in schools, it spruced everybody up and we're all in our best behaviour. I don't care whether there were one or two inspections. I think that it's very clear from the testimonies. We've spent over £1 million through the Truth Recovery Independent Panel, for example, and then the other pieces of research to identify that there was harsh treatment running throughout all of these. So I'm just putting it on record again. I don't care what dates other people, what rationale they had, but I think that I'll certainly be pushing for the posthumous date to be pushed right back, so that we don't cut anybody out of this process.
Yeah, I suppose just to respond in terms of, I suppose those are political decisions, and that's I suppose for the committee and the Assembly to consider that. I suppose what I want to just reassure people is that financial redress is only one form of redress, and I think we have to sort of balance that, in terms of support services, which we heard some. I think there's been some excellent feedback around support services, about information retrieval as a form of redress, investigation as a form of redress, and memorialisation as a form of redress. So I suppose it's not just financial redress.
Appreciate that.
So
I
appreciate your view as well. So.
Thank you. Sorry, there's just one other thing. Apologies. I did want to pick up a point that was raised last week, and that was around some of the language that was used. I think it was in clause 31. Around, I think it was clause 2B, I think you've seen last week, around that they felt that it didn't really reflect the harsh treatment, and it was a wee bit clinical, the wording is. Could you maybe speak to why it was drafted in that way?
Yeah, I suppose what we were trying to make the distinction between was if an individual, and we absolutely understand some people would say, well, I was neither provided shelter nor maintenance as part of this process. What we don't want to do is have such a high bar as well that an individual would actually be eliminated from receiving a redress payment. So I think it's just about trying to have some type of language.
But even using the word confinement, I mean, the issues that we've been dealing with, and you will know better, but there was 12, 13, 14-year-old girls who were pregnant, and no one asked why they got there, what happened to them. And it was clearly a lot of coercion and control by families because of stigma and shame. But, and I know it's not meant this way, but when you're talking about shelter, it's like, give me shelter. It's like a generous, open term. I mean,
like emergency accommodation almost.
Aye. So
I suppose, Carol, what we don't want to do in that provision, so particularly so let's say, I'm using this because I think it was some of the language used last week about, I think someone had used the phrase punishment,
Mm-hmm.
That's what, so I suppose that might feel more reflective of an individual's experience. What we don't want to have as a redress scheme, that basically the discretion of a redress president would have to say, if an individual comes forward and provides an application and there isn't information, we want them to be able to say, oh, I was there for shelter.
Can I just, Martin, I'm 60 and I've had kids. So see, when you go in to have a baby, it's called confinement.
Yeah.
It's a medical term.
Yeah.
And frankly, I'm afraid that if you get a chair, president, whatever, and they're right-wing conservative, where's the protection for people? So all I'm saying is, it is the inquiry's job, along with the panel, to extract all this. But what if it's not?
Yeah, I understand.
So, and they might say, well, it wasn't in the bill. It was down to the Assembly, it's our fault.
Yeah, I suppose, Carol, we don't like we want to make this and hopefully you can see elements in terms of the redress side about having a very simple standardised payment. But I absolutely appreciate your point that you don't want to leave it to too much discretion.
No,
you
we don't.
To want it to be. And like the desire is to provide as many people redress as possible, not the opposite. So.
Was it just the victims and survivors seeing themselves on the face of the bill as well?
Yeah, of course.
Anybody got? Do you have any other points? Go ahead, please.
Whole room here, but you'll be back. So we'll get the legal advice, and then we'll really put your feet to the fire.
I welcome clarification regarding the foster care element. Just on birth fathers, and I know this is a real contentious one, but you've said about this being a gender-based bill. But at the same time, there is fathers who wanted to take responsibility, and basically they were told to just go away.
Yeah, and I suppose well, Francesca, do you want to say?
Burning the ear there, sorry. Well, I think in aspect of the inquiry, the chairperson would welcome a view from all different angles, so that would potentially include a birth father who comes forward to consider evidence. For us, relevant persons are about the persons who were affected, and yes, we understand this we were looking at it as a gender-based thing, but there is the opportunity within the inquiry for other people to provide evidence, and that could be from the like of a birth father, for example. That's not going to be expelled from the inquiry because he wasn't the mother. So that aspect is in there, maybe not plainly on the bill, but an inquiry would look at the circumstance and how the admission. So as part of the admission, how did the admission happen? There maybe was a father, someone has give evidence to say there was a father, the father maybe comes to the inquiry, wishes to give evidence, the chairperson could listen to that evidence, but again, as we say, there's two aspects to this. Some people who maybe find that insensitive, and some people who do want that inclusion, but there is the option without having it there on the relevant person for that birth father to present to the inquiry and give that evidence.
And then for redress, they wouldn't be eligible?
Yeah, for redress, it's very much centred on a gender based, so basically mother and baby institutions and Magdalene Laundries, they were for
baby could be male or female.
Baby could be male or female, yeah.
So it's not right just saying it's gender based essentially.
It's not. I mean, there will be children who are obviously that sort of. There's males and females who are children now adults, so they are victims of these processes as well. But we've made. I suppose the eligibility is tied to a birth mother's admission or a person who was admitted into a laundry they were both of which were female only institutions. So.
I thought you finished, yeah? Okay, I just wanted to pick up on the letter that was shared with us around the Truth Recovery Independent Panel and the information that there's going to be this extension until the report being published in March 2026. Obviously we would have preferred if this had aligned with our scrutiny process, but in the letter, in one of your papers, it had said that £1 million approximately had been spent to June 2025. How much money has been allocated now for this to be extended?
So there's no additional cost to so the independent panel have a budget of £2 million, so there'll be no additional cost over the £2 million. I don't know what the final outturn will be, but it is up to £2 million. It is a time extension rather than a cost extension.
Okay.
But
and so, as we were mentioning earlier there, obviously there was that extra money that was allocated for marketing, and it obviously has proved successful. And people come forward with their testimony, so I'm not going to be churlish about that. But I am conscious that we are going to be spending £5, £6, £7 million on the public inquiry, and I just want to know, have you thought about the sort of technicalities of how the sort of these testimonies, etc., are going to filter in? Because if everything's written, you know what I mean?
Yes.
How will they interface with people giving oral testimonies?
Yeah, so neutral
Sorry,
one.
can we just pause that wee question a wee second? Sorry. I'm sure it's hard listening in here. It's pretty harder listening online.
This is quite regular or something.
It's like literally.
I know when they're going to come through the wall.
I know.
Through the wall.
Could be worse, it could be 7 o'clock on a Sunday morning.
That's,
Like Andrew knows.
yeah.
Just wait until. Just a
Well,
minute.
was there not more money set aside for the public inquiry?
There's about so we've in the EFM we've estimated between 12 and 20.
Sorry, okay, but I'm just saying.
Oh no, but yeah,
But the main scenario we think is about 14 million. So,
Yeah.
yeah. So, and that's a 3-year. So.
Okay. You're right. It was just more to say if we're going to spend all this money and then have the whole inquiry
exactly.
itself.
I suppose in terms of I think in terms of how the panels work will feed in, I suppose there's lots of advantages of having the panel in terms of that oral testimony. So I think they've collected about 237 new testimonies, and that's in addition to testimonies that they had from the previous research. So that provides basically a very strong evidence base to establish about individuals, and in addition to individuals having a participatory role and it being able to take in a safe space, that information provides a bedrock then for the inquiry. So that's a sort of direct advantage for the inquiry. But also the archival records, so PRONE, and they've I think digitised over 5,500 records. So all of those records are now available for both the panel and the inquiry as well. So.
Okay. Go ahead, please, something.
Concerns were raised in the past when we had when the Truth Recovery panel had went out and done the Royal Mail postal delivery, that there was areas were missed. I'm concerned that that there's common towns and cities being mentioned in here, and I'm concerned that potentially some of them areas that have been missed may be in areas where it's likely some of the institutions were. Are you happy out of the 237 and the 350 people that come forward that represents a good geographical spread?
So I don't actually know, Timothy, how geographically wide. I know for a fact that there will be a mix of people. I think what we've found in the HIA process is about maybe 85% are people based in Northern Ireland. There's about 10% who are providing evidence who are generally in England or Scotland or Wales, and then a percentage from the south. So there's generally, I don't know if Francesca's got more figures off the top of her head, but I think we're reasonably confident that we're getting a good sort of a diaspora mix there. So it's not just people who are here. We're also having people coming forward providing evidence here in England, Scotland, Wales, and further afield, Republic of Ireland as well. So I'm happy to provide more information on that, but it's sort of I think we're reasonably confident we're getting a good mix of evidence. So.
I think in our consultation we had Canada, America, New Zealand, and some from Europe as well. So through our diaspora contacts and our work and the consultation, we were able to reach those people. We could have done more, and we will do more in the inquiry, I think, to reach more people. But I think that what was that, we did find that there was people coming from the wider world, I suppose.
When you say you're going to reach more, what does that look like?
I suppose the practical, I think, Timothy, one thing, leaflet drops have been pretty effective actually on HIA, and they've been pretty effective here as well. And I think that's a model that either for the inquiry or redress scheme or jointly, that if once the legislation's passed, that's something you would like to think that would be utilised, and invite people to come forward for inquiry, for redress, but also support services as well. So that's a sort of what I would describe as a do minimum, and then there'll be other sort of campaigns that HIA have, I think, had pretty good effect on some of the digital campaigns that they've ran as well. So
In GB?
In GB, it's been mainly through, I think, Fiona Ryan's team and the Commissioner around sort of trusted channels, networks. There's some groups that HA and Corsica have been engaged in through, but there hasn't been, I think, GB-wide advertising. So.
We did go through the diaspora groups in GB, and that was disseminated through all their groups out for the consultation as well. So we would look at doing that again and maybe potentially looking at how we would widen that. And obviously then with the older demographic, a radio would be more, maybe something that would be more accessible to them, as well as the leaflets. And it's shaping our communication to those people who we're trying to reach, rather than trying to get a big media campaign which is maybe ineffective. So it's just, we will work on how that will go out.
Okay, thank you all.
Okay. Thank you. Thank you.
You'll probably be back before us again. But we appreciate your time for now. Thank you.
You have to mean that, Martin. I'm not really convinced.
Is there a recap? Is there any actions from that, please?
Thank you, Chair. I think the department had said that they will provide us a bit more info on a couple of areas, so one of them being TRIP, that we just discussed about. I think as well on query number 5, which is all about the access to information. And just to say off the back of that, the committee will be hearing legal advice next week on public interest immunity and just on public interest generally, and whether there is anything else that the committee can do. And then the other thing that I just really wanted to raise, the question about sort of the risk of access to info, that the redress scheme might be able to get more info than an individual could. I'm not sure whether that sits within the scope of this particular bill as such, but I could maybe perhaps sort of take some advice on that, and perhaps that's something the committee may wish to get legal advice on, if there was a way that could be shared in the future. But perhaps if you leave that with me, I'll come back to you on that.
I think that the more I hear about this bill and the elements of it, the more I think that we do need a commissioner or an interim advocate or somebody to help. Because when we raised it with Martin before, he said, the campaigners are quite sophisticated, and the more people are coming forward, I think the more we need to ensure that they are supported to be navigated through this. So anyway, just a thought. Any other? Go ahead.
Timing of the regulations.
Yes.
I'm really concerned about those, to be honest.
And again, Chair, our next session with the examiner statutory rules, I know that's something that will be brought up in a few minutes' time.
And it's normal that is it normal that regulations are published after a bill has passed?
Perhaps that's a question we
can
ask.
Angela?
Yes.
Okay.
I wouldn't be able to give you a definitive answer on that. She
right,
will.
Okay.
And then just finally, sorry, Chair, we had asked the department previously if they could produce some sort of easy read guide for the bill itself, and that isn't the explanatory memorandum, because I think there are parts of the explanatory memorandum that are actually quite difficult to read. I wonder if the committee might be minded to go back to find out about that, because again it came up today about not an understanding of some of the language, so we could chase that up if the committee are happy to do that.
Yep. Okay.
I want to set Timothy off, but there's also stuff here. There's also stuff here about EU regulations and that, that
retained.
Like what does that mean for people who are reading it?
I know. Okay, members, are we in agreement that we'll take a 5-minute comfort break and resume 5 minutes? Okay.
Committee Room 21. Sound. 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 Committee Room 21. Sound.
Okay, thank you, members. We're just back in open session now. Just to recap for those watching online, we have had a session with the Examiner of Statutory Rules in relation to the Inquiry and Redress Bill, and then we've had an informal discussion around the draft report into our inquiry into gaps in equality legislation, and a decision was taken that, a discussion was had around deferring sign-off or public session agreement around the report until we've had our evidence session with the Equality Commission, which is scheduled for the 3rd of December. Are we in agreement that we will defer final discussion on the report until we've had the Equality Commission? Okay, I'm seeing nods online as well there. Okay, is there anything else there, Clark?
No, I think we can just move on now to...
Okay, so members, you'll be glad to hear correspondence this week is a lot lighter than previous weeks, so I'm going to refer you to pages 302 to 305 of your pack for the summary of committee correspondence, and I would just want to advise your draw your attention to one item, and then I'll hand over to the clerk, and that is the Committee for Finance has written forwarded us a response, and you'll find this on pages 344 to 346 of your pack, and this is a response from the Commissioner for Children and Young People in terms of the call for evidence regarding the Administrative and Financial Provisions Bill. The Commissioner highlights the issue of powers for TO relating to services for the integration of refugee and asylum seekers, the undertaking of activity in respect to the strategic framework for ending violence against women and girls. The Commissioner has recommended that the Department undertakes a screening and, if required, conduct a child rights assessment in that area. So I'm asking your agreement to note this correspondence and to agree to forward this correspondence to you and ask if a screening process has taken place, and if so, will the results, and if not, will a screening process take place? Are we in agreement? Yeah, okay. Okay, so I'm just going to ask the clerk then to read some other pieces into the record. Thank you.
Thank you, Chair. Members, item 10.2 is the Hansard report from the briefing by the First Minister, Deputy First Ministers and Junior Ministers to this committee on the 10th of September. Item 10.3 is the Hansard report, which is the Raise briefing paper on the Inquiry in Mother and Baby Institutions and Redress Scheme Bill. Item 10.5 is the TEP response to the correspondence of the 30th of May in the TEO budget allocation 25-26 and the local change fund. Item 10.6 is First Minister and Deputy First Minister response to correspondence of the committee of the 15th of May, and that's around the extension of the Troubles Permanent Disablement Payment Scheme. Item 10.7 is a Committee for Finance response to correspondence from the committee on the 27th of June in relation to its work on the Inquiry and Redress Scheme Bill. Item 10.8 is Legal Services, the 44th report of the Examiner of Statutory Rules, and just to note that there are no rules for the attention of this committee. Item 10.9 is a departmental news release about ministers welcoming the launch of Belfast City Airport Master Plan. Item 10.10 is the annual report of the Historical Institutional Abuse Redress Board for year ending 31st of March 2025. And finally, item 0.11 is a written ministerial statement from the First Minister and Deputy First Minister that was issued on the 18th of December regarding the Tier 1 National Pandemic Exercise named Pegasus.
Okay, thank you very much, Clerk. Anybody want to raise any issues in relation to correspondence? No. Okay. Going to the draft forward work programme, please.
Thank you, Chair. So it's just one update, and it's just relation into our roundtable events for next month in relation to the bill. So previously for the 15th of October, obviously the Dungannon session's in the morning and we're still visiting Oma in the afternoon, but just note the change of venue from Wave Trauma Centre. Unfortunately, it's just too small for our needs that day, so we're going to the Silver Birches Hotel instead, which isn't too far from Wave Trauma Centre.
Well, thank you for organising all that. Okay, members, are we content to proceed with the remaining briefings as outlined in the work programme? Yep. Okay. Any other business, members? No? Okay. Okay. Oh, so, did you indicate, Claire? No? No. Okay, sorry. Okay, so members, just to inform that our next meeting will take place on Wednesday the 1st of October at 2 p.m. in this room, so the meeting is adjourned.
Committee Room 21. Sound. Committee Room 21. Sound. Committee Room 21. Sound.